that can be used in your case is a mistake of fact defense. If you act under an honest but reasonable mistake of fact, then you would not be guilty of a crime. This does not mean that ignorance of the law is a defense, meaning that you didn't know you were not allowed to do something and that therefore acts as a mistake of fact defense. That's not how this defense applies. In that circumstance, you're dealing with a mistake of law, which is not a defense to a crime. A good example of mistake of fact is, let's say you're leaving a restaurant late at night, you left your keys in the ignition, you get into a random car that you think is yours with the keys also in the ignition, and then you drive home. You realize shortly thereafter that it's not actually your car, but it's somebody else's car. It just happens to look the same as yours and have the keys in the ignition just like your car. Now, in this circumstance, it would be a mistake of fact because in that circumstance, you were not actually trying to commit the crime of grand theft. You were not actually trying to and actively trying to steal a vehicle from another person with the intent to deprive them of that vehicle. Instead, you made a mistake as to the facts of that case, meaning you believed in good faith that that vehicle was actually yours. So if the facts were as you believed them, you were not stealing a car, you were simply driving your own car home. For more information on a mistake of fact defense, as well as other defenses, call the Inland Empire Criminal Defense today.